Shari'ah Standard Number 10, Salam and Parallel Salam. In the name of Allah, the All-Merciful, the Most Merciful, all praise be to Allah, the Lord of all the worlds, and blessings and peace be upon our Master, Muhammad, and his household and all his companions. Preface. The aim of the standard is to explain the rules for and limitations of Salam and Parallel Salam in respect to concluding a Salam contract, the subject matter of Salam and changes to the contract, whether in the event of ability to deliver or otherwise. The standard also explains rulings in respect to issuing Salam sukuk. Statement of the standard. 1. Scope of the standard. This standard covers Salam and Parallel Salam transactions, whether the institution is the buyer or the seller, and issuing Salam sukuk. This standard does not cover istisna, manufacturing or supplier contract, because the latter is covered by a separate standard. 2. Contract of Salam. 2.1. General Framework for Salam Contracts. 2.1.1. It is permissible to initiate through negotiations several Salam contracts with different parties. Each operation will end at its due date. It is also permissible to draw up a general framework or a master agreement that consists of an understanding to conclude successive Salam contracts, each of which will take place at an appropriate time. In this latter case, the transaction involved shall be concluded on the basis of a memorandum of understanding in which the contracting parties determine the framework of the contract and the intention of the parties to buy and sell. The parties shall also determine the quantity and specifications of the goods, the manner of their delivery, the basis for determining the price, and the manner of payment. The types of guarantees and other prospective arrangements shall also be specified in the memorandum. The execution of each Salam contract may then take place separately at the appropriate date. 2.1.2. If the Salam contract is concluded on the basis of what was initially agreed in the Memorandum of Understanding, the contents of the memorandum become part and parcel of the contract. This will hold true unless the parties agreed when the contract was concluded to exempt themselves from some of the obligations referred to in the Memorandum of Understanding. 2.2. Form of a Salam contract. A contract of Salam may be concluded using the word Salam, or Salaf, or sale, or any term that indicates sale of a prescribed commodity for deferred delivery in exchange for immediate payment of the price. 3. Subject matter of Salam. 3.1. Capital of Salam contract and its conditions. 3.1.1. It is permissible for the capital of Salam to be in the form of fungible goods, such as wheat and other cereals, in which case the parties must make sure that they do not fall into riba. The capital may also be items of material value, such as livestock. It is also permissible for it to be in the form of the general usufruct of a particular asset, such as living in a house, or having the use of an aircraft or a ship for a certain period. In such a case, when a party is granted access to the usufruct through delivery of the asset, this is regarded as immediate receipt, possession, of the Salam capital. 3.1.2. The capital of Salam should be made known to the two parties in a manner that removes all uncertainty and eliminates the possibility of dispute. In principle, the capital of Salam should be in the form of cash. In this case, the currency of payment, the amount and the manner of payment shall be clearly defined. If the capital of Salam is in the form of fungibles, then the kind, type, specifications and quantity of these shall be clearly defined. 3.1.3. The capital in a Salam contract must be paid immediately at the place where the contract is concluded. However, as an exception to this ruling, payment may be delayed for 2 or 3 days at 1. Fungibles are goods that share common features such that they do not differ significantly. Any fungibles can be replaced by any other in the event of destruction, without need to assess the value of the item destroyed or the one replacing it. Even if such a short delay has been stipulated earlier, this will not affect the Salam contract provided that the period of delay is not equal to or greater than the delivery period for al-Muslim fihi. 3.1.4. It is not permitted that a debt be recognized as the capital of Salam, such as using as the capital of Salam loans or debts owed by the seller to the institution as a result of previous transactions. 3.2. Al-Muslim fihi and its conditions. 3.2.1. Salam contracts are permitted for fungible goods, like those that may be weighed, measured, or counted, the articles of which do not differ in any significant manner, provided that no riba ensues. 3.2.2. Among the items for which variations in numbers make no difference are the products of companies that manufacture goods in approximate units that are identified by trademarks, standardized specifications, and are regularly and commonly available at any time. However, this rule must be read together with item 3.2.8, 3.2.3. Salam is not permitted for anything specific like this car. Nor is it permitted for anything for which the seller may not be held responsible, like land, buildings or trees, or for articles whose values change according to subjective assessment, like jewelry and antiques. Also, it is not permissible to stipulate that al-Muslim fihi must be from a specific piece of land. However, on the delivery date the seller may present the buyer with whatever items are available, and meet the contract specifications, irrespective of whether such items are from his own fields or factories or elsewhere. 3.2.4. It is not permissible for al-Muslim fihi to be an amount of currency, gold or silver, if the capital of the Salam contract was paid in the form of currency, gold or silver. 3.2.5. Al-Muslim fihi must be the kind of article for which a specification may be drawn up so that the seller may be held responsible for its conformity to the specification. It will be sufficient if the specification is explained in a manner that removes uncertainty, except for minor discrepancies that are customarily ignored, considered acceptable, and not usually regarded as grounds for dispute. 3.2.6. It is a requirement that al-Muslim fihi be clearly known to the contracting parties in a manner that eliminates any possibility of uncertainty or ambiguity. The reference for determining descriptions that are used to specify and identify al-Muslim fihi is customary practice and the experience of experts. 3.2.7. It is a requirement that the parties know the quantity of al-Muslim fihi. The quantity of each item is determined according to its condition and nature with regard to weight, measurement, volume and number. 3.2.8. It is a requirement that al-Muslim fihi be commonly available under normal circumstances at the place where it should be on the delivery date, so that the commodity will be accessible to the seller in order to discharge his obligation by delivering it to the buyer. 3.2.9. It is a requirement that the date of delivery for al-Muslim fihi be known in a manner that eliminates any uncertainty or ambiguity which may lead to a dispute. There is no Shari'ah objection to the contracting parties setting various dates on which the delivery of al-Muslim fihi may take place, in installments, provided the capital of Salam was paid at the time the contract was originally concluded. 3.2.10. In principle, the parties may designate the place at which al-Muslim fihi is to be delivered. If the parties to the contract do not determine the place of delivery, then the place at which the contract was concluded will be regarded as the place of delivery unless it turns out to be impossible to make delivery to such a place. In that case, the place of delivery should be determined according to customary practice. 3.3. Security for al-Muslim fihi. Al-Muslim fihi may be secured by a mortgagee or a guarantee or any other permissible means of securing payment. 4. Changes to al-Muslim fihi. 4.1. Selling al-Muslim fihi before taking possession. It is not permitted for the buyer to sell al-Muslim fihi before taking possession of it. 4.2. Replacement of al-Muslim fihi. It is permissible for the buyer to exchange al-Muslim fihi for other goods, except currency, after the delivery date falls due, as long as such a substitution was not stipulated in the contract. This rule applies whether or not the substitute is similar in kind to al-Muslim fihi. This is provided that the substitute is suitable for being exchanged as al-Muslim fihi for the capital of the Salam contract, and that the market value of the substitute should not be greater than the market value of al-Muslim fihi at the time of delivery. 4.3. Cancellation, ikala, of a Salam contract. It is permissible, when both parties agree, to cancel the entire Salam contract in return for repayment in full of the amount of the capital of Salam. Partial cancellation, that is, cancellation of the delivery of part of al-Muslim fihi, in return for repayment of a corresponding part of the capital of Salam, is also permissible. 5. Delivery of al-Muslim fihi. 5.1. The seller is under an obligation to deliver al-Muslim fihi to the buyer on the due date in accordance with the terms of the contract, such as agreed specifications and quantity. The buyer, on the other hand, must accept the goods if they meet the specifications explained in the contract. If the buyer refuses to accept al-Muslim fihi, he shall be compelled to do so. 5.2. If the seller offers delivered goods of a quality that is superior to that required by the contractual specifications, the buyer must accept the goods, provided that the seller shall not seek a higher price for the better quality. This may be considered one of the ways in which a contract is ethically fulfilled. However, this will apply only if the inferior description specified in the contract is not itself deemed vital. 5.3. If the quality of the delivered goods is inferior to that required by the contractual specifications, the buyer is entitled either to reject or to accept the goods in that condition. If he accepts the goods, his action is considered as ethical acceptance. It is also permissible for the two parties to agree to a settlement on terms for acceptance of the goods even at a discounted price. 5.4. It is not permitted for a seller to deliver al-Muslim fihi in the form of a commodity different from the one agreed upon if the commodity is considered to belong to the same genus as al-Muslim fihi. Example, al-Muslim fihi is corn and the commodity that the seller wants to deliver is wheat. However, the delivery of al-Muslim fihi in the form of a different type of commodity from that agreed upon may take place only on the basis of the conditions for the replacement of al-Muslim fihi by other goods. See item 4.2. 5.5. Delivery of al-Muslim fihi may take place before the due date, on condition that the goods conform to the agreed specifications and quantities. If the buyer has a valid reason for rejecting the goods, then he will not be compelled to accept them. Otherwise, the buyer will be forced to accept the goods. 5.6. If the seller fails to perform his obligation, owing to insolvency, he should be granted an extension of time for delivery. 5.7. It is not permitted to stipulate a penalty clause in respect of delay in the delivery of al-Muslim fihi. 5.8. In case all or part of al-Muslim fihi is not available to the seller on the due date, the buyer shall have the following options. 5.8.1. To wait until al-Muslim fihi is available. 5.8.2. To cancel the contract and recover the paid capital. It is also permissible for the parties to agree to replacement of al-Muslim fihi by other goods. See item 4.2.6. Parallel Salam. 6.1. It is permissible for the seller to enter into a separate, independent Salam contract with a third party in order to acquire goods of a similar specification to those specified in the first Salam contract, so that the first Salam obligation will be discharged by delivering these goods. Hence, the seller in the first Salam contract becomes the buyer in the second Salam contract. 6.2. It is permissible for the buyer to conclude a separate parallel Salam with a third party for the purpose of selling, on the basis of Salam, a commodity whose description corresponds to the description of the commodity to be acquired through the first Salam contract. In this situation, the buyer in the first Salam contract becomes the seller in the second Salam contract. 6.3. In both the two situations mentioned in items 6.1 and 6.2, it is not permissible for the parties to link the obligations under the two Salam contracts together so that the execution of the obligations of one contract is contingent on the outcome of the other. Hence, it is necessary that both the obligations and the rights under the two contracts stand alone in all respects. Therefore, if one party breaches his obligation under the first Salam contract, the other party, the injured party, has no right to relate this damage or loss to the party with whom he concluded a parallel Salam. Consequently, he has no right on the basis of his loss or damage under the first Salam contract to terminate the second Salam contract or to delay in performing it. 6.4. All the rules of Salam as explained in items 1 to 5 above are applicable to parallel Salam as well. 7. Salam sukuk issues. It is not permitted to issue tradable sukuk based on the debt from a Salam contract. See item 4.1.